Welcome to Federal Briefroom, a channel dedicated to calm, fact-based analysis of America's most important legal and institutional moments. We don't chase outrage, we don't amplify noise. We focus on what actually happened, why it matters, and what it means for the future of American democracy. What unfolded today inside a federal courtroom in Manhattan was not just another legal dispute. It was not a procedural disagreement. It was not political theater, at least not at first. What happened today was a direct test of whether the rule of law can still function when powerful individuals decide that normal boundaries no longer apply. If you care about the survival of American institutions, this is a story you need to understand from the beginning, without slogans, without spin, and without manufactured outrage. Shortly before noon today, during an active federal court session, something occurred that veteran legal observers say they have rarely, if ever, witnessed in modern American judicial history. At approximately 11:47 a.m., while a federal judge was in the middle of delivering a ruling from the bench, three senior defense attorneys rose from the defense table, gathered their documents, and attempted to walk out of the courtroom. Let's be very clear about what that means. These were not spectators reacting emotionally. These were not protesters staging a demonstration. These were licensed officers of the court, attorneys sworn to uphold the Constitution, attempting to abandon an ongoing federal proceeding because they disagreed with a judicial ruling. Federal courtrooms are not informal spaces. They operate under strict rules, rigid hierarchy, and deeply ingrained norms. Attorneys do not walk out. They do not test the authority of the bench in real time. And they certainly do not attempt to leave while a judge is mid-sentence. Until today. To understand why this moment matters, we need to step back and examine what led up to it, because this did not come out of nowhere. The morning session began in a way that court observers initially described as routine. The prosecution sought to admit a large set of financial documents into evidence. The defense objected on relevance and prejudice grounds. This is standard procedure in complex white-collar cases. Nothing about the early exchanges suggested the day would spiral into chaos. But behind the scenes, pressure had been building. 48 hours before today's hearing, a sealed filing was briefly exposed on PACER, the federal court's electronic record system. According to court officials, the exposure occurred due to a clerical error. The document was visible for approximately 17 minutes before being removed. 17 minutes was enough. Legal researchers monitoring the docket captured the filing before it disappeared. Multiple individuals familiar with the contents have since confirmed what it contained and why it immediately set off alarms within the defense community. According to those sources, the filing included newly submitted prosecution evidence consisting of encrypted communications between the defendant and several co-defendants during a period the defense had previously described as a complete blackout, a time when they claimed absolutely no contact had occurred. Alongside those communications were financial records detailing wire transfers totaling approximately $4.7 million. One individual who reviewed the documents described them as the most complete financial paper trail ever assembled in a white-collar prosecution of this scale. This morning, Judge Patricia Caldwell ruled that all 847 pages of that material were admissible. That ruling changed the temperature in the room instantly. Court transcripts show that moments after the ruling, lead defense counsel stood and accused the court of abandoning impartiality. A second attorney followed, alleging prosecutorial misconduct. Then, without requesting permission, the defense team turned toward the exits. That is when the courtroom froze. Judge Caldwell is not known for theatrics. She is a Reagan-appointed federal judge with over 3 decades on the bench. She has a reputation for discipline, restraint, and fairness. Defense attorneys often consider her courtroom one of the most predictable and professionally run venues in the federal system. Her response was immediate. She warned the attorneys that if they took one more step toward the door, she would hold them in criminal contempt and issue bench warrants for their arrest. She then ordered United States Marshals to secure every exit. Within seconds, armed federal marshals positioned themselves at all doors. What followed was a silent standoff lasting just over 7 minutes. 7 minutes during which some of the most powerful attorneys in the country realized they had crossed a line that could not be undone. Eventually, the defense team returned to their seats. But the damage was already done. Because moments later, Judge Caldwell revealed information that explained why the defense appeared so desperate to leave that courtroom. She disclosed on the record that earlier that morning she had received a sealed ex parte submission from the Department of Justice. In federal practice, ex parte communications are extraordinarily rare. Judges avoid them whenever possible. They are typically reserved for matters involving national security, witness safety, or circumstances so sensitive that disclosure could cause immediate harm. Judge Caldwell stated that based on the contents of that filing, she was considering enhanced courtroom security measures and the potential sequestration of the jury. Every experienced criminal defense attorney understands what that signals. It suggests the presence of a cooperating witness. Someone on the inside. Someone whose testimony carries not just legal weight, but personal risk. Within hours, former federal prosecutors publicly acknowledged what the defense team almost certainly understood in that moment. The prosecution appears to have secured testimony from an insider with direct knowledge of the financial core of the case. At that point, what looked like indignation began to resemble something else entirely. Not outrage, fear. And that realization is what moves this story from courtroom drama into something far more consequential, which is where we go next. Once the defense attorneys returned to their seats after that 7-minute standoff, the courtroom technically resumed its normal rhythm. But in reality, nothing about this trial was normal anymore. What had just happened fundamentally altered the posture of the case. Within 30 minutes of the proceedings restarting, the defense team filed 2 emergency motions. The first requested an immediate mistrial, citing what they described as judicial bias and prosecutorial misconduct. The second sought the recusal of Judge Patricia Caldwell herself, arguing that her warning of contempt demonstrated personal hostility toward the defense. On paper, these motions followed established legal procedure. In practice, however, experienced observers recognized something else at work. This was not simply about disagreement with a ruling. This was about creating a record. In high-stakes federal trials, attorneys think several moves ahead. Every objection, every exchange, every ruling becomes potential appellate material. By provoking a dramatic confrontation with the bench, the defense manufactured a narrative, one that could later be presented not just to an appeals court, but to the public. And that distinction matters, because trials are decided by judges and juries. But perceptions are shaped far beyond the courtroom. Legal analysts quickly noted that the walkout attempt accomplished several strategic objectives at once. It framed the defense as defiant rather than cornered. It created headlines suggesting institutional conflict. And it laid groundwork for future claims that the proceedings were fundamentally unfair. Whether those claims succeed legally is almost beside the point. Their real value lies elsewhere. By mid-afternoon, the focus of coverage had already shifted. Instead of discussing the admissibility of financial evidence, the public conversation revolved around judicial authority, alleged overreach, and courtroom drama. That is not accidental. Judge Caldwell appeared keenly aware of this dynamic. Later that day, she addressed the record again, making clear that the court would not tolerate tactics designed to manipulate proceedings through disruption. She emphasized that allowing attorneys to abandon a client mid-trial would set a dangerous precedent, one that could encourage any defendant facing unfavorable rulings to manufacture a mistrial. Her reasoning was straightforward. If walking out becomes an option, then every trial becomes vulnerable. Justice would no longer be determined by evidence, but by who is willing to push boundaries furthest. This is why federal judges guard courtroom authority so closely. Not out of ego, but out of necessity. Behind the scenes, the consequences of the defense's actions were already rippling outward. According to multiple reports, the law firm representing the defendant convened emergency internal meetings by Friday evening. Senior partners reportedly expressed concern about professional exposure, not just reputationally, but financially. Malpractice liability is a quiet but powerful force in the legal profession. If a court later determines that counsel intentionally engaged in conduct that harmed a client's interests, insurance coverage can be withdrawn. In extreme cases, partners can face personal financial risk. Bloomberg later reported that the firm entered urgent discussions with its malpractice insurer amid fears that continued courtroom disruptions could jeopardize coverage. This is not theoretical. In past federal cases where attorneys engaged in contemptuous behavior, insurers have refused to defend claims arising from that conduct. Firms have collapsed under the weight of litigation that followed. At the same time, political messaging accelerated at remarkable speed. Within minutes of the walkout attempt, statements appeared framing the judge's actions as authoritarian. Social media posts accused the court of election interference. The language was familiar, sharp, emotional, and designed to mobilize supporters rather than clarify facts. What stood out to analysts was not the content of those messages, but their timing. Several commentators appeared ready with talking points almost immediately. Camera crews were already positioned outside the courthouse before the incident became public. That level of readiness suggests anticipation, not surprise. Judge Caldwell would later address this concern directly. In a written order issued that evening, she stated that the court had reason to believe certain elements of the day's events may have been coordinated with outside parties for purposes unrelated to the fair administration of justice. She warned that any future attempts to transform the courtroom into a political stage would be met with sanctions, including contempt proceedings and referrals to bar authorities. That language is highly unusual. Federal judges do not lightly accuse attorneys of coordinating theatrics. When such warnings appear in a written order, they are meant to signal seriousness, not just to the parties involved, but to any reviewing court. Meanwhile, security around the courthouse was quietly escalated. Additional screening measures were implemented. Law enforcement presence increased. During the afternoon session, court security alerted the judge to the presence of individuals associated with extremist groups near the courthouse perimeter. No direct threat was identified, but the information added another layer of concern. Federal judges take such signals seriously, particularly when cases involve heightened political tension. Inside the courtroom, the jury was not present during the initial standoff, but jurors are perceptive. They notice tone, they notice tension, and they notice when a trial feels unstable. Jury consultants note that when defense attorneys appear combative toward the judge, jurors rarely interpret it as courage. More often, they interpret it as desperation. One consultant summarized it bluntly: jurors tend to believe that lawyers only risk their own careers when they believe the evidence is overwhelming. That perception can be devastating. By the end of the day, it was clear that the defense had succeeded in changing the conversation, but it was far less clear that they had improved their position. And looming over everything was the detail Judge Caldwell revealed earlier: the sealed ex parte submission. Because whatever strategy the defense believed it was executing, it was now operating under a new reality. There is a witness. That witness is protected, and their testimony has not yet been heard. That is where this case moves next, and why the stakes are about to rise dramatically. As the court adjourned for the day, attention inside legal circles shifted rapidly toward one unresolved issue: the sealed ex parte submission Judge Caldwell referenced from the bench. By Friday evening, multiple sources with direct knowledge of the proceedings confirmed what many had already suspected. The Department of Justice is preparing to call a cooperating witness identified in court filings only as Witness 14. That designation alone carries significance. In complex federal prosecutions, witness numbers are not assigned casually. By the time the government reaches double digits, it usually indicates a case built around layered testimony, corroboration, and internal cooperation. Witness 14 is not an outsider. This is someone deeply embedded in the financial structure at the center of the case. According to individuals familiar with the matter, Witness 14 has been in protective custody since October. That detail is critical. Protective custody is expensive, disruptive, and rarely used unless prosecutors believe there is a credible safety risk. It suggests the witness possesses information powerful enough to provoke retaliation, or at minimum, intense pressure. Legal analysts immediately began narrowing the possibilities. The prevailing theory points towards someone inside the defendant's financial operation: a controller, senior accountant, or executive responsible for authorizing or processing transactions. Someone with direct access to records, internal communications, and decision-making channels. If that assessment is correct, the defense is facing one of the most difficult scenarios in white-collar litigation. Jurors may debate motives. They may question intent. But they tend to trust documents, especially when those documents are explained by someone who once handled them personally. Insider testimony paired with financial records is devastating when presented cleanly and methodically. This context reframes the defense's conduct earlier in the day. What appeared outwardly as protest now looks increasingly like anticipatory damage control. The timing supports that conclusion. The attempted walkout occurred exactly 4 days before Witness 14 is scheduled to testify. In trial strategy, that window is not arbitrary. It represents the last realistic opportunity to derail proceedings before a pivotal evidentiary moment. If a mistrial could be forced, or even delayed, the government's momentum could be disrupted. Witness schedules could be thrown into question. The narrative could shift from evidence to procedure. That possibility helps explain what happened next. After the standoff, Judge Caldwell disclosed that she was considering appointing shadow counsel for the defense. This is an extraordinary step. It means the court would assign additional attorneys to sit alongside the defense team, prepared to step in immediately if current counsel withdraws or is removed. Shadow counsel exists for one purpose: to prevent defendants from sabotaging their own trials by manipulating representation. In effect, the court signaled that it would not allow theatrics, no matter how dramatic, to derail the process. The implications were immediate and serious. Reports indicate that senior partners at the defense firm convened an emergency meeting late Friday night. According to industry sources, malpractice exposure became a central concern. If a court later determines that counsel engaged in intentional misconduct, insurance coverage can be jeopardized. That is not hypothetical. In prior federal cases involving contempt or disruptive conduct, insurers have declined coverage entirely, leaving firms exposed to millions in potential liability. By the end of the evening, Bloomberg reported that the firm had entered urgent discussions with its malpractice carrier. Sources suggested the insurer was evaluating whether continued representation under current conditions posed unacceptable risk. At the same time, political messaging intensified. Statements appeared framing the courtroom confrontation as proof of judicial overreach. Social media posts accused the court of bias. The language was familiar, designed less to persuade jurors than to mobilize supporters. What stood out was the speed. Several commentators appeared ready with narratives almost instantly. Media crews were already positioned outside the courthouse before full details became public. That level of preparedness suggests coordination, not coincidence. Judge Caldwell appears to have noticed the same pattern. In a written order issued later that night, she warned that the court had reason to believe aspects of the day's proceedings may have been coordinated with outside parties for purposes unrelated to justice. She stated plainly that future attempts to convert the courtroom into political theater would be met with sanctions, including contempt, financial penalties, and referrals to bar authorities. That warning matters. Federal judges rarely make such statements unless they believe the integrity of the process is under threat. And by this point, it was clear the trial had reached a breaking point. As this case moves forward, Judge Caldwell now faces one of the most difficult balancing acts any federal judge can confront. If she allows the defense team to withdraw, the trial could be delayed for months. New counsel would require time to review thousands of pages of evidence, interview witnesses, and reconstruct strategy. Such a delay could push the proceedings well into an election cycle, a result that would benefit the defense politically but undermine the court's authority. If she forces the defense to continue, she risks creating appellate arguments centered on ineffective assistance of counsel, even if those arguments ultimately fail. Legal scholars describe this situation as a manufactured dilemma. By engaging in disruptive conduct, the defense has attempted to limit the court's options, ensuring that every path forward carries some degree of risk. Meanwhile, prosecutors are reportedly considering their own responses. One option being discussed, though viewed as unlikely to succeed, involves revisiting bail conditions. The theory would argue that conduct designed to undermine judicial proceedings demonstrates a willingness to flout court authority. Even the consideration of such a move underscores how volatile the situation has become. Inside the courtroom, the jury remains the silent audience to all of this. Although jurors were not present during the initial walkout attempt, they are keen observers of tone and stability. Jury consultants note that visible conflict between the bench and defense counsel often harms the defense more than the prosecution. When lawyers appear to challenge the authority of the judge, jurors rarely see heroism. More often, they see disorder, and they associate that disorder with the party causing it. That perception can linger long after objections are resolved. Monday's rulings will be pivotal. Judge Caldwell is expected to rule on the defense motions for mistrial and recusal. She will also determine whether witness 14 will testify as scheduled. Sources indicate that U.S. Marshals have been briefed on arrest procedures for attorneys, an extraordinary step that underscores how seriously the court is taking the possibility of further disruption. That alone should signal how unprecedented this moment is. International observers are watching closely. Legal commentators abroad have expressed disbelief, noting that similar conduct in many jurisdictions would result in immediate custody. Adversarial media outlets have seized on the story as evidence of institutional weakness. This is not abstract damage. It affects how the United States is perceived as a nation governed by law rather than personality. Behind the scenes, discussions are reportedly underway about replacing the entire defense team. Names being floated include attorneys known for aggressive, polarizing tactics. The apparent strategy is escalation. Turn the trial itself into a political battleground. But escalation carries consequences. Courts enforce boundaries. Judges possess contempt powers for a reason. Bar associations investigate misconduct. And juries ultimately decide credibility. What happened in that Manhattan courtroom may be remembered as the moment when aggressive strategy crossed into self-inflicted harm, because this case is no longer just about guilt or innocence. It is about whether American courtrooms remain places where law governs, or whether they become extensions of political campaigns. The coming days will answer that question. When witness 14 takes the stand, when the judge rules, when the defense decides whether to comply or provoke. Federal Briefroom will be here for all of it. Because what happens next will not just shape this trial, it will shape how justice is practiced in this country going forward.